Hello, veterans, Tech AV employees, everybody watching here at the Veteran Lang channel. Welcome as always. This video is going to be quite late in the day on Tuesday. We got busy again. We got a lot of veterans to help. We're signing up more and more veterans every day. So, hey, if you want to talk to your friendly VA accredited attorney, Matthew Lang here, see if we can help represent you. Don't forget to go to veteranlang.com. Click on our link there. Check us out. Let's have that conversation. We help veterans nationwide. We can have the phone call. If you're in the Arizona area, stop in. Say hi. Let's chat and see how we can help you out. Let's see if we can untangle your VA claim, get some appeals granted for you, and ultimately get you all the benefits that you deserve. Hey, so here's what we do. For those who don't know, here at the channel, we talk about VA compensation mostly. We've been trying to squeeze in some other VA benefits a little bit as well. But we ultimately want to make the process between VA and veterans alike smoother, more efficient. We want veterans to not have to be as stressed and to, perceivingly struggle as much to get the benefits that they deserve. Those that were promised to them when they signed that contract and signed on that dotted line. So today, here's the topic for you that I want to talk about. And it's something that may sound boring. I think a lot of these topics could definitely sound boring, especially when we talk about rules and regulations and so forth. But this can have a major impact on a VA claim. The prescribed form requirement and what makes a VA claim complete or substantially complete. Before I go into all of what I've got written here to stay on track, let me jump off track really quick, veterans. This is a realm that's still fairly young when it comes to the idea of prescribed form requirements and substantially complete claims. When I first started working at the VA, we were still in paper files. And we were also in a world of laws that said it didn't matter how that claim was filed. If it, as we jokingly always said, filed on a piece of toilet paper, it was a valid claim, and we had to accept it at that. So many times claims would get lost. Claims were buried inside of correspondence. Other statements, they're not always the easiest to spot. So over time, we now have this prescribed form requirement and this idea of whether that form is complete or at least substantially complete when it is filed. And that's what we're going to talk about today. I do get questions about this here at the firm. You may find other representatives will take different approaches to this and how they complete these forms, as these forms may cover multiple pieces of information, may duplicate questions, or they may not provide enough space to answer those questions clearly. And you may find your representative providing additional correspondence to explain some of that information without having to put it on the form. So I want to give you an idea here of what we're looking for, or at least the VA is looking for underneath the rules, or should be looking for, veterans, so you understand what a substantially complete claim is and what that prescribed form may be for the type of claim you're filing, or appeal in most cases. And for VA, I'm going to give you some practice tip in here that we're going to talk about on something I see and that's misunderstood underneath the law. I'm going to give you my perspective of it, and you can do as you wish with it. Hopefully, you'll take it and you'll add it to your toolbox and utilize it to help the veterans. All right, enough of that. Let's jump into it. So ultimately, the prescribed form and the substantially complete form matters because sometimes the issue in a VA claim is not the medical evidence yet. Sometimes the issue starts before that medical evidence in some awkward way. Sometimes the first question is did the VA receive the right form? And then the second question is was that form complete enough for the VA to act on it? Now, for some that may sound technical, but it can affect whether VA processes your claim or not, veterans. Whether VA has to notify the claimant about missing information, whether VA's duty to assist is triggered, and sometimes whether an earlier effective date is preserved. So let's break down this topic more. Under 38 U.S.C. 5101, a specific claim generally has to be filed in the form prescribed by the Secretary before VA benefits may be paid or furnished. Now, that is a statutory foundation for the prescribed form. In plain English, VA usually does not have to treat every statement, letter, or piece of paper, as they did before, as a claim for benefits. VA can require the claimant or the veteran to use the proper form for the type of benefit that's being reviewed or being requested. Now, that is why we have different forms for different lanes. For example, if a veteran is filing an initial disability compensation claim, this is generally going to be on a VA Form 21-526EZ. If the veteran is filing a supplemental claim, this is a VA Form 20-0995. If the veteran is requesting a higher level review, that's VA Form 20-0996. If the veteran is appealing to the Board of Veterans' Appeals, that's VA Form 10182 or 10182. The form matters because the form tells VA what lane the claimant is in. Original claim, new claim, increased claim lane areas, supplemental claim lanes, higher level review claim lanes, Board of Veterans' Appeals lanes. So a veteran saying, I disagree, may be expressing disagreement, but under the modernized review system, VA generally needs to know which review option the veteran is choosing. Supplemental claim, higher level review, Board of Appeal. So just from a standpoint and from experience, when we look back at the rules before all of this prescribed claim rule came out, we had found that when veterans would write, I disagree, or I want to reconsider my claim, or reopen my claim, or words of the like, it created a lot of confusion because the rules weren't really clear on what that meant. Were they appealing? Were they not appealing? So this is one reason, as I had experienced, why we've came about these laws and why we now focus in on these prescribed forms to help the VA understand what lane your file, your claim, your appeal needs to be in, veterans. All right, so moving back to our point here, the first point is simple. The right form gets you into the right lane. But using the right form is not the end of the analysis, veterans. It's not the end. The next question is whether the form is complete enough. Now hear that carefully. Complete enough. I imagine for most, when we talk about complete, we think about every box filled out. But complete enough sure indicates that not every box is necessary, even though it's on the form. So let's take a deeper dive. VA's regulation at 38 CFR 3.155 says a complete claim is required for all types of claims and generally is considered filed on the date VA receives it. That same regulation also explains the intent to file process. If VA receives a proper intent to file, and then VA receives the complete application form prescribed by the Secretary within 1 year, VA may treat the complete claim as filed as of the date VA received the intent to file. Now, that's a very important distinction because an intent to file is not the same thing as a complete claim. Intent to file is a mere placeholder. So think of it as the placeholder and not the complete claim. It can protect a potential effective date, but only if the claimant or veteran later submits the complete prescribed form or substantially complete prescribed form within the required time of 1 year. And I think this is where veterans and other people may get confused. So let's see if we can clear that up. So a veteran might submit an intent to file and even write medical conditions on it. But identifying medical conditions on an intent to file does not automatically convert that intent to file to a complete claim or a substantially complete application. The complete claim still has to come later on the proper form. So I would say it this way. An intent to file may preserve the date, but it does not replace the claim. Now, where do we find the definition of a complete claim? Well, that's in 38 CFR 3.160A. The complete claim must be on the application form prescribed by the secretary, whether paper or electronic. It generally has to include the claimant's name, the relationship to the veteran if applicable, enough service information for VA to verify service if applicable, a signature by the claimant or someone legally authorized to sign, identification of the benefit sought, and a description of the symptoms or medical conditions to the extent the form requires. Now, if anybody's seen, for example, a VA Form 21-526EZ, you'll realize that there are many more boxes than just those on the form. So while it may be beneficial to fill out those additional boxes, understand the law doesn't make it a requirement to be a complete form. Now, since we're talking about some of these forms, let's talk about the supplemental claim. For supplemental claims, the regulation adds a specific requirement. It says to be a complete form, potentially new evidence must be identified or included. I'm highlighting the identified part because VA, this is where we're going to eventually get into the idea of a practice tip from my experience working inside the VA, my experience as a VA accredited attorney, and something that I think can help you out and understand the rule a little bit better. So this last sentence is very important. Potentially new evidence must be identified or included. So, for you veterans, it's not enough for a supplemental claim just to simply say, I disagree, again and again and again. Or please review this claim. Please review your last decision. Or please review this again. The supplemental claim lane is built around new and relevant evidence. Now, does that mean the veteran must physically attach new evidence to the supplemental claim form? Not necessarily. The regulation says potentially new evidence must be identified or included. So there are two possibilities. The veteran can include the evidence. This is fairly common. So for example, attach a new medical opinion, private treatment records, a buddy statement, a new DBQ, or some other evidence. Or, veteran can identify the evidence. For example, the veteran can say, there are VA treatment records from, let's use Phoenix because I'm in the Arizona area, from the Phoenix VA Medical Center from 2021 to 2024 that relate to my claimed back condition. Or there are private orthopedic records from Dr. Smith from March 2023 to July 2023, and I have provided the release. Now that distinction matters. No new evidence attached is not always fatal. And VA, I say that again, no new evidence attached is not always fatal. We do see a lot of the bad and ugly, so when I refer to the bad and ugly, I want VA to understand that I know not everybody makes this mistake. It doesn't happen all the time. Not everybody takes this action, but we see it so frequently that when the evidence is identified and not attached, we will get a straight up denial that there was no new and relevant evidence. So understand that no new evidence actually attached is not always fatal. Now, if there's no new evidence submitted or identified at all, veterans, this is where we're going to have a problem because now the VA is going to be in the right. So this is where the duty to assist errors can become important. And this is one spot where myself and the team here may focus if we're filing a supplemental claim for you veterans, and I'm just pulling that curtain back and letting you know. This is our strategy. This is something we've done. It's not the strategy we take on every claim. Every claim is unique. Every appeal is unique, but it's something we've done. It's something others may do. It may be something that others may decide not to do. All of us representatives have a different way of getting to the same result, just as all of us people have different ways of getting to the same destination or result. So let's say VA previously denied a claim because there was no nexus. But in the prior claim, the veteran had identified relevant VA treatment records or service treatment records or private records, and VA failed to obtain them before issuing the decision. If the veteran is still within the appeal window, well, one option may be the higher level review. The HLR reviewer can look at the record as it exists at the time of the prior decision and determine whether VA made a duty to assist error. But if the appeal window is expired, the veteran may no longer be able to request the HLR on that old decision. At that point, the veteran may need to use the supplemental claim lane, and this is why we may pick this strategy from back here. And this raises a good question. Can a supplemental claim be substantially complete if the veteran is not attaching a new medical record, but is identifying missing evidence that VA previously failed to obtain? The answer should be yes. If the veteran is actually identifying potentially new and relevant evidence, the key is that the veteran should not merely say VA made a duty to assist error. That's a conclusion. The better approach from my point of view and my experience is to identify the evidence connected to the error. And many times what we will file is additional memorandums or legal briefs to explain all that to the VA and cross our fingers that somebody reads it. So, for example, VA previously denied service connection for my back condition. In the prior claim, VA did not obtain my service treatment records from Fort Hood from March 2009 through July 2009, where I was treated after a training injury. Now, remember, this is all hypothetical. So, as I say me, just know it's not exactly something that's happened to me. It's just all hypothetical. It's not something that's happened to any veteran we've dealt with either. But those records are relevant to the in-service injury element of my claim. Now that's much stronger to write than there's a duty to assist error. Just for another example, we could write something along the lines of VA denied my PTSD claim because there was no verified stressor. VA did not obtain my service personnel records and unit records from my deployment with whichever unit during whatever the date range was. Those records may be able to verify or may verify the claim stressor. Again, this is not saying VA made an error. This is identifying potentially new and relevant evidence. That evidence that was not obtained would be new and potentially relevant. So a supplemental claim can be complete without the veteran uploading a brand new nexus letter. If the veteran identifies evidence, VA can help obtain that evidence if potentially new and relevant. That also lines up with 38 CFR 3.2501, which says that when VA receives a substantially complete supplemental claim, VA's duty to assist is triggered. This includes the assistance that may help secure new and relevant evidence to complete the supplemental claim application. So if the supplemental claim lane, let me take that back. So in the supplemental claim lane, the duty to assist is not triggered by a vague request to review again. It is triggered when VA receives substantially complete supplemental claim, and for a supplemental claim to be complete, potentially new evidence must be identified or included. So again, it's just the new evidence, potentially new evidence has to be identified or included. That is the practical rule. Now let's compare that with a higher level review, since we were talking about that before. And we know the higher level review is different. In an HLR, the evidentiary record is closed. We can't provide any more evidence. The HLR adjudicator generally reviews the record as is, as it existed at the time of the decision being reviewed. New evidence is not allowed. As I mentioned, new evidence is not allowed in the HLR lane. VA's public guidance says HLR is for situations where the claimant does not have new evidence to submit and is requesting review within 1 year of a decision. But the HLR reviewer does have to look for certain errors, including whether VA complied with the duty to assist before the prior decision was issued. So under 38 CFR 3.2601, if the HLR adjudicator identifies a duty to assist error that existed at the time of the decision under review and the reviewer cannot grant the maximum benefit, the claim must be returned for correction of the error and readjudication. VA's own public-facing explanation says that if VA finds a duty to assist error during an HLR review or during an HLR, VA will close the review and open a new claim to gather the missing evidence. Or actually, what they're going to do is open a claim underneath a supplemental claim to gather the new evidence. VA will then help get the missing evidence and decide the case based on the new evidence. So there is a distinction I want veterans and VA employees to understand. In an HLR, the reviewer can identify a duty to assist error, but the missing evidence still needs to be developed. The HLR reviewer generally cannot just develop that evidence inside the HLR lane and then grant or deny based on that new evidence. The claim must be returned for correction and readjudication back to the supplemental claim lane. Are you getting what I'm throwing down? The rules say identified. If a duty to assist error is occurred, that could be the identifiable statement or argument of new evidence. And it's even expressed so by the actions of the HLR. For even the HLR, when they find a duty to assist and realize there is potentially new evidence to make the decision of the claim, they too send it back to the supplemental claim. So here's a simple way to explain it. HLR is for reviewing the old record. Supplemental claim is for adding or identifying new evidence. If the HLR reviewer sees the VA should have obtained evidence before the decision, that is a duty to assist problem. But once evidence needs to be gathered, the case has to leave the closed record HLR posture. Now let's tie that back into incomplete applications, because that's where we started, right? Under 38 USC 5102, if a claimant's application is incomplete, VA must notify the claimant and the claimant's representative. If any representative, the representative must also be notified of the information necessary to complete the application. If the information is not received within the required time, benefits generally cannot be paid or furnished based on that application. So when VA receives a form that is missing required information, the question is not always, can VA just ignore it? The question may be, did VA receive the prescribed form? What required information was missing? Because remember, not every box has to be filled out on all forms. The law provides a list of what makes the form substantially complete or complete. Did VA notify the claimant and representative of what was needed to complete the application? And did the claimant respond within the required time? For most incomplete application issues under 38 CFR 3.155, make sure I said that right, 3.155, if a complete claim is later submitted within the required period, the date of the earlier incomplete application or intent to file may matter. But supplemental claims have their own special timing rule in general. So under 38 CFR 3.155, if VA receives a complete supplemental claim within 60 days of VA's notice that an incomplete supplemental claim was filed, it will be considered filed as the date VA received the incomplete supplemental claim. Now, that's the general on the surface. And as you know, how much I love the law because there's exceptions, there's going to be other rules that could come into play. But I always want to give you the basic foundation to work with here. So understand, that's the general rule. If you've provided a supplemental claim, and the general rule ultimately lands on that date of claim as the date of your effective date, veterans, but that supplemental claim was incomplete, you'll usually get about 60 days to complete that claim, file it again, for it to go back to the date that the incomplete claim was filed. Now, that's important because timing can affect effective dates. So here's a few examples. Example 1, a veteran files a VA Form 20-0995 and writes, "I disagree with the prior denial. No new evidence is attached. No new evidence is identified. No missing records are identified. No duty to assist error is explained." This is a weak supplemental claim. The problem is not simply that the veteran failed to attach evidence. The bigger issue is that the veteran did not identify or include potentially new evidence. So, VA then would have to tell the veteran what made this 20-0995, a supplemental claim, incomplete, and veterans, you would have your time frame to respond, ultimately to save the effective date on the general rule of the date of the supplemental claim. Now, don't get me wrong, there's some ITF issues that might fall in there. There's some other pursued claims rules that will fall in there. But just to stay out of the weeds, that's the surface of the idea. Now, here's example number 2. A veteran files VA Form 20-0995 and writes, "I seek readjudication of my denied knee claim. VA denied the claim because there was no evidence of an in-service knee injury. VA did not obtain my service treatment records from Camp Pendleton from June 2012 through September 2012, where I was treated after a training injury. Please obtain these records." Now that's different than the first example. The veteran has identified potentially new and relevant evidence. The records were not previously considered, and they may relate directly to an element VA said was missing. So that would be a substantially complete or a complete claim, assuming all the other elements have been met that we discussed earlier, like identifying information and signature. Now we can go on with multiple examples and go best and better and greatest example and so forth. But I think you get the idea with those two examples here, veterans. This is why what lane you file things in may matter. This is why you have to look towards the prescribed form to make sure you're in those right lanes. This is why you have to make sure the minimum requirements for those prescribed forms are met underneath the law in order to make them substantially complete. So here's the big takeaway. A prescribed form matters because VA needs the correct lane. VA needs to know, veterans, where your claim goes. Unlike back in the day, before all these rules, where we weren't sure and claims were getting lost because we were like, is a reconsideration an appeal? Is a reopen an appeal? Are we within the 1 year time period? Are we outside the 1 year? What's going on? No, is that a claim for an increase when they say reconsideration? What's happening here? We had to take away that confusion. So this was the answer to take away that confusion. help the VA understand what you're trying to claim veterans and what lane to put that in. New claim, original claim, increased claim, a supplemental claim, higher lower review, Board of Veterans Appeals, and so forth. So prescribed form really matters to help the VA put it in the correct lane. So the veterans, this is how we can help the VA in order to make the process smoother. A complete claim matters because, well, VA needs enough information to act. They don't need all the information on those forms. Again, that could vary depending on how you decide to fill that out, veterans, on your own, or how your representative decides to approach that. Many times, like I said, for our point of view, that information is duplicate. The questions are duplicated on the form. So why put it in two spots and confuse the issue? Sometimes that informational box to put that information isn't big enough, and almost never big enough to write everything we need in there. We may decide to put that on a different form or a different letterhead that is attached to the claim form. The idea here is that the complete claim matters as long as VA's got enough to act upon according to the law. We want to make sure they have at least the basics and the minimum in order to act on your claim. A supplemental claim must identify or include potentially new evidence. And I really highlighted this one because of the bad and the ugly that we see on the supplemental claims. We will see VA go, nope, didn't attach any new evidence. And they'll be like, well, we decided then to gather recent VA treatment records, even though you didn't identify them either. And then they'll say that, yeah, those weren't relevant, and so we deny your claim. But ultimately, what's happening here is they're overlooking the identifying of evidence part in those duty to assist errors and that additional write-up that we like to put in order to explain all that, because the examples I gave here, sure, would be helpful, but we find that sometimes more needs to be said instead of just those one or two sentences. So keep in mind, supplemental claim must identify or include potential new evidence. And a duty to assist error can be very important, but the veteran should connect that error to the actual missing evidence. Don't just say there's an error. Got to explain it. Give an idea where the evidence is, perhaps. Maybe a date range, if you can, veterans. Why the evidence may be relevant. This is how you're going to make the supplemental claims conquer. And that's what we ultimately work to do back here. And from the VA side, when an application is incomplete, the issue is not just clerical. The question becomes whether VA provided the proper notice of what was needed to complete the application. Under 38 USC 5102, VA has a notice obligation. When an application is incomplete, they've got to notify you, veterans, and if you have a representative, your representative as well, of why that is incomplete or why they feel it is incomplete. And under the regulations, the timing of when the claimant completes the application can ultimately matter for your effective date. So for this educational platform video today, for you veterans and everybody watching, the practical message is going to be this. Use the right form. Identify the benefit or issue. Sign the form. And for supplemental claims, at the bare minimum, identify the potential new evidence. And if you can, always include it. And if you're raising a duty to assist error, do not just name the error, identify the missing evidence the error relates to. Because supplemental claim may be the only avenue you have, veterans, to identify that duty to assist error, because you may not have the opportunity to file the HLR or the Board of Veterans Appeals if you're outside of that 1 year line. So we've got to address the error somehow. We do it by identifying the potential new evidence. I thank you, everybody. I'm going to leave you with those those final words there. Much longer video than we've normally have done. They're probably going to get a little bit longer. I'll try to keep them even shorter. But these are the rules and things that I like to share to ultimately make the process smoother. There's definitely different points of views, different perspectives of things, and different outlooks on the way the rules work. I like to give it to you with my experience from inside the VA, from outside the VA, from ways we've handled claims, the way we address issues. If I can ultimately give you that information, then maybe you don't need me in the future, and the whole process is now smoother and more efficient between veterans and VA alike for veterans to get those benefits they rightfully deserve. And that's the ultimate goal. That's what I'm here for. Suppose one last plug. If you're still sticking around at this point in the video, hey, don't forget veteranlane.com. Check us out. If you want representation, you can find the button on the website there to schedule some time with myself, phone call or here in person in Arizona. Now, remember, I'm not the only representative out there. We have hundreds and probably thousands, actually, of other representatives, VSOs, accredited agents, and other accredited attorneys that are there to help too. Be with who you're comfortable with if you want a representative, is all I ever ask, and make sure you seek that representative for help before you give up. Make sure you get those claims you deserve, veterans. You raised the hand, you served, you fought, you accepted the injuries with pride. Now get what you rightfully deserved. All right. Thank you again, everybody. Enjoy the rest of your week and have a fantastic week. And I'll see you in next Tuesday's video, if not sooner.